Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh. Welcome to the Sikh Channel Legal Show, live legal program. Aaj sana jure hoege Senior Solicitor Mr. Andrew Lucas. Andrew, the Bakili practice hoege Cardiff, which is capital of Wales. Cardiff the bitch hega, par sara ida kam hega England and Wales. ਤੁਹਾਨੂੰ ਪਤਾ ਹੋ ਸਕਦਾ ਕਿ Scotland ਵੱਖਰੀ legal system ਹੈਗੀ, England and Wales the legal system ਇੱਕ ਹੈਗੀ ਆ, and Andrew Lucas is based in Wales in Cardiff. From there he covers the whole of England and Wales with a specialist area. Andrew ਦਾ ਕੰਮ ਜ਼ਿਆਦਾ ਹੈਗਾ ਜਾਇਦਾਦ ਦਾ, ਜਦੋਂ ਕੋਈ ਜਾਇਦਾਦ ਦੀ ਕੋਈ dispute ਹੋ ਜਾਵੇ, ਕੋਈ ਸਹਿਮਤੀ ਨਾ ਹੋਵੇ, ਕੋਈ ਮਾਪੇ ਜਾਂ ਸਿਆਣੇ ਚੜਾਈ ਕਰ ਜਾਣ, ਉਹਨਾਂ ਤੋਂ ਬਾਅਦ ਉਹਨਾਂ ਦੀ ਪ੍ਰਾਪਰਟੀਆਂ ਹੈਗੀਆਂ, ਵਿਲ ਹੈਗੀ, ਵਸੀਅਤ ਹੈਗੀ, ਉਹਦਾ ਫਿਰ ਆਪਸ ਵਿੱਚ ਹੀ ਕਈ ਵਾਰੀ ਨਹੀਂ ਸਹਿਮਤ ਹੁੰਦੇ ਵੀ ਕਿਸ ਤਰ੍ਹਾਂ ਇੱਕੋ ਜਿਹੇ ਹਿੱਸੇ ਹੋਣੇ ਚਾਹੀਦੇ, ਉਹ ਸਾਰਾ ਕੰਮ ਐਂਡਰੂ ਲੂਕਸ ਕਰਦਾ. Andrew, welcome to the Sikh Channel live legal program. I was introducing you as a contentious probate specialist who covers the whole of England and Wales, and I explained that you help people when they have disputes over estates after the passing of a loved one. It's a difficult subject, a subject fraught with emotional turmoil. I mean, do these cases end up in court, or what's your experience of them? Can people avoid litigation? Because litigation can be a horrible thing.
Well, firstly, yes, indeed, Davinder, and good evening to you, and good evening to everyone on the Sikh Channel watching this evening. And yes, I specialise in contentious probate litigation. Well, all litigation is something that nobody wants to become involved with if they can. It's expensive and it's stressful, but in my experience, usually contentious probate disputes do result in an amicable settlement between the parties, and I've often found that at the end of the process it can be cathartic. It can almost heal divisions within the family. Once the dispute is resolved, it can clear the air.
Andrew, ਕਹਿੰਦਾ ਵੀ ਇਹਦੇ ਕੇਸਾਂ ਦੇ ਵਿੱਚ ਫੈਮਿਲੀ 'ਚ ਝਗੜਾ ਹੋ ਸਕਦਾ ਜਾਇਦਾਦ ਪਿੱਛੇ, ਪਰ ਕੋਰਟ ਜਾਣ ਦੀ ਕਈ ਵਾਰੀ ਲੋੜ ਨਹੀਂ ਹੁੰਦੀ, ਐਂਡ ਯੂਜੂਅਲੀ ਐਂਡਰੂ ਦੀ ਇਹੀ ਕੋਸ਼ਿਸ਼ ਹੁੰਦੀ ਵੀ ਕੋਰਟ ਦੇ ਬਾਹਰ ਸਾਰਾ ਕੇਸ ਸੈਟਲ ਹੋ ਜਾਵੇ. ਜੇ ਕਿਸੇ ਕੋਲ ਸਵਾਲ ਹੈਗਾ ਤੁਸੀਂ ਟੈਲੀਫੋਨ ਵੀ ਕਰ ਸਕਦੇ 0121 380 1050, ਐਂਡ ਤੁਸੀਂ ਸਵਾਲ ਕਰ ਸਕਦੇ ਇੰਗਲਿਸ਼ ਦੇ ਵਿੱਚ, ਜੇ ਪੰਜਾਬੀ 'ਚ ਕਰਨੀ ਫਿਰ ਮੈਂ ਪੰਜਾਬੀ ਭਾਸ਼ਾ ਦੇ ਵਿੱਚ ਐਂਡਰੂ ਨੂੰ ਉਹ ਸਵਾਲ ਪੇਸ਼ ਕਰ ਸਕਦਾ. Andrew, most common is challenging a will. I've had a number of clients in the last couple of months where there's a valid will and people are not happy with the will. And a common question is about lack of capacity and sound mind. Can a person challenge a will if they think there's been coercion or the person was not aware of what they were doing? And are these two separate matters? Coercion, is that a separate matter to be having testamentary capacity, having knowledge and state of mind?
Generally so, it's a separate matter. Lack of testamentary capacity is you're not mentally fit enough to know what you're signing. It often happens in the case of a will because, not always, but often the people who make wills are elderly. They may be in ill health. That may be the reason they make a will. And you can have a situation where someone has, say, dementia, and it can be the case that they simply don't know what they're signing at the time. You also can have a situation where, which is more difficult to prove, somebody may be mentally well for periods of time, but then unwell. That can also happen. Coercion is where somebody is forced to make a will. So you can have a situation where somebody is fully mentally able and understands what they're signing, but pressure is brought upon them to make a will, and they therefore do it really against their will. They're forced into signing it.
Thank you very much. And as you know, we're dealing with the Sikh community on the Sikh channel, or the Punjabi community. We have lots of different viewers from across the world, from all communities watch the Sikh channel, not just Sikhs. We have Hindus also watching the channel, and who come from Punjab, who share language and culture. So culture is a very strong element, and often if a will deviates because of culture from expectation, does that lead to disputes? For example, in the traditional Punjabi culture, there has been a tendency in past generations, to only leave the assets to male heirs, to sons, excluding daughters. Have you come across that situation and helped to
I
rectify?
have come across that situation, and indeed it does lead to disputes, because English law, well, under an English will, a testator person, by which I mean a person who makes a will, can leave their estate to whoever they want to. But if a will is made and it only leaves the estate to sons or to an elder son, it does open the door to a daughter saying, "This is unjust. Provision should be made for me in the will." So yes, potentially that situation can lead to a challenge of a will in England and Wales. There are two ways around that, and it really depends who you're advising. If I was advising the testator, and he wanted to leave his estate to his sons or to his eldest son, which of course he could do, I would want to draft for him a watertight will, possibly with a side letter explaining why he was doing that. Conversely, if I was advising a daughter to challenge a will, her argument would be this will is unjust. Perhaps pressure has been brought to bear on the sons, by the sons on the father, or because it's a cultural expectation. Maybe there's been coercion. Maybe the daughter is dependent on the father because she is a daughter and perhaps doesn't work, and she would have what's known as a dependency claim. So you can approach those cases from two angles, depending on what you want to do, really, and what your objectives are.
Where there's a joint family who lived, and again, in the Sikh community, the Indian community, people live in joint circumstances. The elderly parents may live with one son or in a joint family, and that son may feel he has a greater right over what happens to their estate. Have you come across that, and how do you resolve that?
I I have come across that scenario. Um, the secret to overcoming problems in that situation is really a well drafted will, explaining that the one son, eldest son, the son who's looking after the parents, let's say, is receiving the estate because he has, perhaps with his own wife, provided care for the elderly parents during their lifetime, and it's for that reason that the dispositions, the bequests under the will, are being left in this particular way. So really, that's very much a case of prevention is better than cure. The secret really is a well-drafted will, maybe with either some explanation in the will itself as to why the estate is being bequeathed in a particular way, or maybe a side letter which forms no part of the will but can be deposited with the solicitor, explaining in depth what has actually happened, why the will is being left in a particular way.
But that's not a silver bullet. A very well drafted will, executed very well, compliant by a senior solicitor such as yourself, with a codicil, a side letter, and so on. It can still be challenged. Is that right?
It could be challenged. Any will can be challenged. The question is whether the will is sufficiently watertight to overcome the challenge. A well-drafted will should be able to overcome a challenge to it. There's other things a solicitor can do to protect his client's position in that sort of circumstance. A well-drafted attendance note on the file explaining what's gone on. If the testator, person who makes the will, is elderly, perhaps there could be a certificate from a doctor obtained, which could be placed on file just to protect the position. So whilst any will can be challenged, if you wanted to head off a challenge, that is the best way to go about it. Well-drafted will, maybe an explanatory side letter, attendance note, and as I say, if there's any question of mental capacity, letter from a doctor explaining things. Those are the sort of precautions that you'd sensibly take if you think your will is going to be challenged.
And what is an executor? Who and what is an executor of a will?
An executor is quite simply the person who fulfills the testator's intentions. So what happens is it's up to the executor to actually ensure that the bequests in the will are paid out. When a person dies, the executor will typically sell the person's assets, i.e., obtain money from their bank accounts, sell shares if they have shares, perhaps sell property or transfer property, and really ensure that the terms of the will are fulfilled. An executor is different from a beneficiary, because a beneficiary receives payments, bequests under a will. An executor often doesn't. An executor and the beneficiary can be one and the same, but an executor, particularly if it's a professional, such as a solicitor, won't receive any personal benefit under the will, but will just ensure that the terms of the will are performed to the as the testator wished, in accordance with the will.
And have you come across disputes involving the executors where the beneficiaries have taken to court or had a legal dispute with executors? And if so, why do these arise?
Well, they sometimes arise because the executor doesn't always carry out the wishes of the will. And what can sometimes happen is beneficiaries can apply to the court to remove an executor and appoint an alternative executor. Often this will be an independent person, such as a solicitor. You go to court, you get an order replacing the executor under a will with a neutral executor. As I say, typically it's a solicitor, but it's somebody who has no interest in the will or the circumstances where the will has been made, and they can be relied upon to fulfill the will if the existing executor isn't fulfilling the will. If they do nothing, for example, or if they don't ensure that the bequests go to the right people, or they don't distribute the will, you go to court and you'd remove the executor, or you'd apply to do so.
And if somebody feels they're being treated unjustly or not receive their fair share of an estate, what can they do and when should they do it?
Well, if that's the case, the first thing to do is to write to the executor and say you're not distributing the will appropriately. They've then got two choices. They can go to court and get an order that the executor performs his obligations under the will and distributes the correct share of the estate, or, and probably you do this more usually, if you're unsatisfied with the executor, you'd make an application to the court to remove the executor and appoint a nominated person who was neutral, and a judge would approve that appointment. And then you could be sure you've got a neutral, independent person administering the estate.
And how long does this all take? Sounds like a very complex procedure. Is it expensive? And how long does it take?
Well, it's going to take a couple of months, that procedure, removing the executor. It would be an application to the court. It would go before a judge would consider it. He'd consider, the executor would have, the new executor would have to be happy to take the appointment, and typically the judge would want to be satisfied that they were a correct caliber of person to take on the appointment as a neutral executor. Typically they'd have to show that they had a current practicing certificate, that they didn't have any judgments against them, that there were no disciplinary matters against them, that they were experienced in handling probate matters. So firstly, that sort of process would undoubtedly be done. You'd go to a solicitor to do that, usually. The solicitor would then locate another solicitor or other person who could act as an independent executor. That person would be nominated and an application would go before a court, and then a judge would decide upon it. If it was unopposed, potentially it could happen quite quickly. If the existing executor didn't oppose the application, it could even potentially happen on paper without a hearing. Of course, if the existing executor opposed their removal, it's a different matter. There'd have to be a hearing. But what I've found is usually if there's any doubt as to the behaviour of an executor, a judge tends to favour the executor's removal and the appointment of a suitably qualified neutral person to administer the estate.
In terms of acting in a timely fashion, because if somebody's passed away, what is probate? What is a grant of probate? And can the house or the property be sold and the money disappear? So what would you say about acting in a timely manner?
Well, if you're a beneficiary of a will and you want to challenge a will, it's very important that you act promptly and register what's known as a caveat with the probate registry. Now, a caveat is basically a caution which prevents a grant of probate being issued. Now, the importance of a grant of probate is, grant of probate firstly is a document issued by the probate registry, and it enables the executor to realise the assets of the estate, typically the larger assets. For example, if the deceased person owned a house, the only way that house could be sold or could be transferred was with a grant of probate. But you're quite right, if things are allowed to drift and a grant of probate is obtained, unchallenged, then the executor can actually sell the house and distribute the proceeds, and by which time, if the money's gone, typically the money's gone. It's very hard to get money back once it has gone. So it's always best, if you want to dispute a will, to enter a caveat and to act quickly before the grant is obtained.
In terms of acting quickly, what do you mean? Is that referring to days, weeks, or months?
Well, it depends on the complexity of the will. A complicated will, it can take the probate registry perhaps 8 or 9 months to issue a grant. A simple will is different. It can be issued within a month. So the sooner the better, really. If a person's passed away and you want to challenge their will, you really need to be thinking about acting within a month to 6 weeks. The probate registry are getting much quicker in processing simple probates as well, which don't involve inheritance tax. You know, they were taking 3 to 4 months earlier this year. This week I had a probate I applied for last month granted. So they are much quicker now than they were a couple of months ago. They're working hard to clear their backlog. So it's more important than ever that if somebody wants to dispute a will, they act quickly before the grant is issued.
That's tremendous. Thank you very much, Andrew. And clients often wish to avoid court because of the expense, the trauma, and the time it can take. Can you give an example of a recent mediation which you attended?
Yes, well, you're quite right. Going to court is to be avoided simply because a trial is very expensive. Um, the best way to resolve a probate dispute is via mediation. And what I mean by mediation, for your viewers who perhaps don't know, is an independent person is appointed, a mediator. They do this for a living, they professionally mediate disputes, and the mediator liaises with both sides and tries to achieve a settlement which works for both parties. That'll usually happen over the course of a day. Mediation might be in a hotel, in a solicitor's office, wherever, neutral venue. But it happens over the course of a day, and the mediation seeks to establish common ground between the parties and achieve a settlement. Most of these cases in practice, probably well over 90%, I would say, are resolved via a mediation or a negotiation as opposed to having to go to court. So it doesn't necessarily follow that once one embarks on the process of litigation, one will end up in a courtroom at a trial.
That's tremendous. Thank you very much. In the past, there's been a lot of stigma attached to these type of cases, but we are seeing greater frequency and willingness of people to take up their rights, their just entitlement. And there's a shift in people's attitude. What would you like to say about that? People who might be a little bit um, cautious or reluctant or feel it's not the right thing to do to take up their rights if they feel they've been aggrieved or left out of a will. Is any stigma attached to making a claim?
You're quite right. This sort of these claims have become more popular over recent years, and I suppose it's a point of view as to whether it's a good thing or a bad thing. Like most lawyers, I would say that the important thing is that justice is achieved, and if somebody receives unjust enrichment, money that they're not entitled to, clearly somebody is therefore prejudiced. And if you're the person being prejudiced, you don't want to be prejudiced. So if you feel there is an injustice, it's always better, I think, if the injustice is challenged. It's also a lesson to other people, of course, that they can't get away with it. If people who want to deny somebody their bequest under a will feel they're going to be challenged, they're less likely to do it. So in that sense, it's good. It's good for everyone, if I can put it like that. It does, in a way, achieve a more just outcome. Can also be good within families in a strange way as well, because as opposed to these disputes being allowed to fester, it brings it out in the open, and it resolves it, and then the family can move on and hopefully reconcile. Whereas, as opposed to it being a case of it's never challenged, but let's say brother and sister don't speak to each other again, which is a sad outcome. At least this does, air all these issues and achieve a resolution within the family.
That's tremendous. And you're a practicing solicitor in this particular area. You're happy to help anybody who has any difficulty. And would you offer a no-win, no-fee service?
I would, yes. I do offer no win, no fee. It depends very much on the particular circumstances, of course, the strength of the case, sometimes the size of the case, because the size of the estate. Because in fairness to the client, it's a very small estate, the last thing you want to do is have a solicitor who's taking a big chunk out of a small estate. So each case is case specific, but yes, I do, along with other solicitors, offer no win, no fee in these sort of circumstances.
Because you're based in Wales, in Cardiff, confidentiality is very important. Whilst Cardiff is a centre, a commercial centre in the United Kingdom, it's a little bit out of the way in terms of the general Punjabi population being based in the Midlands, Greater London. So confidentiality is a very important element.
Yes, it is. It is very important, confidentiality. My service is confidential, as in fairness, all solicitors aim to keep information confidential. It's a requirement of our code of conduct, but it is absolutely confidential. And I myself provide a nationwide service throughout England and Wales, as you rightly say, not Scotland, which has a different legal system to the one in England and Wales. But yes, I act for litigants all over the country, frequently in London, frequently in the Midlands. So yeah, and of course, if necessary, I'm happy to travel, and as are my colleagues, and indeed we can have in this age of technology, interactions virtually, such as we're having now, Davinder.
Absolutely. Andrew, thank you very much for joining us, giving your valuable time and expertise to the Sikh Channel viewers, and shedding an insight into claims where people wish to contest a will or challenge an estate. Thank you for joining all the viewers on Sikh Channel, and we hope to see you again soon. Perhaps on our next legal program, you may bring a guest with you and offer a different perspective. We'd be delighted to welcome one of your fellow professionals.
Well, thank you for that, and maybe on the next program we can touch on other dimensions to this, like lasting powers of attorney, which are often made at the time of wills and trusts, and other dimensions to this involved subject. But thank you for having me on your channel this evening, and I'll wish a good evening to all your viewers, and also if I don't see them before, a happy holiday to everybody.
Thank you very much, Mr. Andrew Lucas, Solicitor, Contentious Probate. Thank you for joining us.
Thank you.
Waheguru Ji Ka Khalsa, Waheguru Ji Ki Fateh.